Good afternoon, students. In this conference, we will look at the following chapter. 1. Civil liability. Civil liability is defined as the obligation to repair the damage resulting either from the non-performance of a contract, contractual liability, or from the violation of the general duty not to cause any damage to other by his personal act, or from those things of which one has custody or because of the person for whom one respects liability for the act of other. When the liability is not contractual, it is said to be delictual or quasi-delictual. There are two types of civil liability provided from the Article 104.20 to 115 of the Civil Code: intellectual liability and contractual liability. Civil liability in contract depend on the will of the parties, whereas civil liability in turn is based on events. 1. Contractual civil liability. A. The condition of liability. The mechanism of contractual liability is based on three conditions: the damage, the fault, and the causal link between the two. This liability may be subject to limitation and exception depending on the case. It gives rise to legal action to repair the damage. 1. The existence of damage. Damage is synonymous with prejudice. Can be a material damage, delivery of a broken object, for example, financial loss of money; moral or bodily injury linked in particular to physical injury. The damage must be legitimate, in fact, situation contrary to public order and morality cannot give the right to any liability. For example, a drug dealer who is not paid cannot claim reimbursement for his action in court. The severity of the damage can give rise to potential assessment, for example, in terms of accident. 2. The existence of fault. It can be a voluntary fault or not, error in the date of delivery. In order to properly analyze the notion of fault and its importance, it is necessary to distinguish between the obligation of result and the obligation of mean. The obligation of result requires the debtor to achieve a precise and determinate result. For example, when a mason has to repair a roof, if he does not succeed, the mere fact that the result is not achieved gives rise to his responsibility. Whether or not he was conscientious in his work, the proof is easy. It suffices to note that the result has not been achieved to engage the contractual liability of the party which has not respected its obligation. The obligation of means appears more complex. Indeed, the debtor is not bound by a pending result. For example, a lawyer is not obliged to win the lawsuit he plead on behalf of his client. His responsibility only exists from the moment he has not implemented all the means necessary to achieve the best possible result. Under this condition, proof appears more difficult to provide because it is not enough to prove that the result has not been achieved. It must be shown that the party has not put all the chances on his side to success in satisfying the customer. The fraudulent fault consists in the will not to carry out the contract. The gross fault does not allow limitation or exemption of the responsibility. 3. The existence of a causal link. This link between the fault and the damage, which appear to be essential, can be proved by any means. There must be a direct causal relationship between the fault and the damage. The causal link must be direct. Thus, when the post office does not deliver the mail within the requirement time, a prejudice exists for the person who does not receive a check, for example, which does not allow his pay his creditor in time, but if he himself is waiting for the check to settle another debt, he cannot attack the post office. The causal link not being direct. At the end, for more detail, I will ask you to consult the conference disposed in the platform on PDF format.